We just filed our amended motion to quash Blake Lively. This is war. Welcome to Popcorn Planet. I am Andy Signore. We've been live. The audience has been meeting our lawyers, Jack Gordon, Dave Mitchell. Welcome to the show, fellas. Thank you for all the energy, the positivity. And Dave, I thank you so much for some of the amazing things we're going to write in here. And Jack, your passion on just how much this is. I want you to say it again quickly if you can. This is an attempt to silence our voices, is it not? Free speech. How important is this this story?
The whole nature of the legal process is to, it's an effort to give someone their day in court. And in this particular circumstance, Blake Lively has issued these subpoenas not for the purpose of otherwise garnering information to assist her in her day in court. Again, the sexual harassment claim and the claims against Wayfair and Blvd. Rather, she's utilizing the legal process and the subpoena powers to essentially muffle, silence, and mute newscasters, news information. There are some negative news stories about her, and she's trying to squelch those, again, in a manner that is outside the scope of what the purpose of the subpoena was all about.
So it's a step too far, in your opinion.
It is. It's not for the proper purpose, and more importantly, it's being done in a manner that exceeds the scope of the law as to what is permitted. And Dave can speak more definitively about this. But we have rules of federal rules of civil procedure. You can't go burden a third party who has no dog in the fight, right? This claim is between Lively
and I want you to explain that, because here we have it. We have it on screen.
Doesn't have a dog in that fight. Yet, nevertheless, you're being asked. You're being legally required to expend time, energy, effort, and resources to provide information when she could just as easily garner that from the defendants. She's circumventing that process, and she is otherwise violating your privileges and your rights as a news source. It's in violation of the First Amendment. Dave can speak more specifically about it, given his higher
hallelujah,
legal
amen.
IQ.
Well said. Dave, I want to come to it because I want you to explain, why are we sending this actually in the Middle District, Florida of Tampa division? Now, I know it's where I live, but can you explain why we've filed this motion in the Florida court and not the New York federal court?
Sure. Rule 45, which is the rule that governs non-party subpoenas, that's the Federal Rules of Civil Procedure, states that any motions to either compel production of documents that are requested in a subpoena or to quash such a subpoena shall be made in the district where compliance is required, that being here in Tampa, Florida. So that means the Middle District of Florida, since it's federal.
But in all fairness, Dave, I mean, if we chose to, we could have filed it in the Southern District of New York. But by virtue of the fact that there is the compliance is required by Andy here in Tampa, we're essentially given the opportunity to select forums.
Right, and the court can, at its discretion, transfer the motion to the originating court, which would be the Southern District of New York. But oftentimes they'll just keep it here and decide it here. So we'll have to see.
Well, because it's a massive inconvenience for me.
We were very fortunate, Andy, because again, it's random. But when you file an action like we have here in the Middle District, again, there's 3 districts, federal districts. There's multiple courts throughout the state. Those are state courts. There are 3 district courts, which are U.S. district federal courts in Florida, southern, northern, middle. Because your compliance was to occur and because Popcorn Planet's headquarters and studios are here in the Middle District, again, we can discretionarily request relief here. And for us, I think it's somewhat fortunate because, again, it's random. When you file a case like we have here, they assign it to a judge randomly. It's not as if we can request a particular court. But here in this instance, they have assigned this case to Judge William Young, who is an incredibly bright judge. This is a guy who I've always maintained admiration for. He was in private practice for many, many, many years. I had many cases against his firm. We've never been on the same side. It's always been averse. But I've always maintained a tremendous degree of respect. Like me, he went to school in the southeastern United States. After we got out of law school, again, he's about 10 years older, but both of us went ahead and served as clerks for federal judges. And then ultimately, here's how good and how smart Judge Young is. He was asked by Justice William Rehnquist to serve as a lawyer clerk in the United States Supreme Court, which he did in the mid-'80s. Wow. So Judge Young is very, very familiar with the United States Constitution. He's very, very familiar with the laws, and he is not one to otherwise be swayed by anything other than legal propriety.
So
And
no
that's important
celebrity
for us.
wine and dining there is going to fool him. He's going to go straight by the book. And I guess that's that because look, it's a massive inconvenience for me to have to go to New York, all this stuff. I'm in Florida, and there are rules that protect me as a Florida citizen. And yeah, of course we're going to take advantage of that and use that because that's the way it's supposed to go.
But remember, this is still, again, this is not something that's dispositive, Ange or Kim, and Dave knows this as well. The court has discretion to say, I'm going to pass on making decisions regarding this motion. Rather, I am going to defer and transfer this matter to Judge Lyman up in the Southern District of New York in Manhattan. So again, you got to stay tuned. Nothing is sure. Nothing is certain in the law. There's a whole heck of a lot more gray than there is black and white, guys. And this is, we're going to have to see how this thing unfolds.
There's a pretty heavy burden, though, for the moving party, which would be Lively in this case, to request that transfer. It's not just simply, that, hey, we think it would be easier in New York. I don't want to go into all the, granular detail, but it's a pretty heavy standard to meet. So, in all likelihood, it'll stay here.
We feel confident. We can't make any guarantees, but we do.
Right, but now Blake has to come to Florida to actually do it here, which I kind of love because that's the way it should be. You want to come get my data? Come get it. That's a nice way to do. All right, so here it is, and now you guys understand the Florida of it all. And again, you break down Rule 54.
45.
Sorry, 45. Sorry, thank you. I'm dyslexic sometimes when I read these things. It's a lot. We're going to read this in the longer thing, but Dave, to sort of summarize where we're going, you're going into the privilege of the reporter's privilege, which is again Rule 54. Sorry, 45.
45.
Thank you, 45. God, that's why I don't make these contracts. Thank 45. God they do it.
Yeah, 45
by the way, the privilege is not part of the Federal Rule of Civil Procedure. It's rather
in a way
it's a separate law, separate rule. But from our perspective, we never even have to get to the reporter's or journalist privilege because she hasn't complied strictly with Rule 45. But Dave, again, will do a much better job as go
ahead, yeah, Dave. Dave was like, no, you're wrong, Jack. Say it, Dave. Go for it.
No, he's not wrong. He's it's more complicated than that. Rule 45 simply states that the bases for which a court is required to quash a subpoena, there's certain enumerated factors, but two of those are, one, that it's a privileged matter. The material that's sought is privileged. There are lots of different privileges. This is just one, the reporter's privilege. The other is that it's unduly burdensome to the requested party. So that also goes into some of the stuff that we're going to address in the motion later on.
So the argument goes into again, now we go into Rule 45. Party attorney responsible for issuing and serving subpoena must take reasonable steps to avoid imposing undue burden. There we go, as we just said. The court for the district where compliance is required must enforce the duty to impose appropriate sanctions, which I think the judge has already denied them, hasn't he, Kim?
I'm sorry?
Didn't Judge Lyman already try to... He's done a lot of negative stuff towards these creators and sanctions already, hasn't he?
That wouldn't apply here.
It wouldn't, I know, but I'm just saying he's already trying to squash all those, but yes.
Right.
I don't have the documents in front of me and I can't read them verbatim, but my understanding is at this time there have been a few of the motions to quash at this time that have been declared moot. So by that ruling at that point, then the requests that were within those motions have been denied because the actual motion has been declared as moot. Now, that being said, some of those creators are still fighting back and they are putting things forth. They're putting motions forth on the docket and letters saying, hey, we got targeted for no good reason. They can't tell us why we were subpoenaed. And if they can't tell us why, I don't know why we're being harassed and having to spend our own money and time and the stress and emotional distress that goes through this whole process. So we would like that to be heard, as well as other creators are arguing that their privacy needs to be protected through this whole situation. They are nervous about being doxxed. They are nervous about their private information getting out and their children being at risk and things of that nature. So there's a lot of going back and forth right now on the docket.
Yeah, it's ugly. It's ugly out there. But all right, focusing on the subpoena, because I know a lot of you have been wondering, and we'll get to all that later. So reporter's privilege, we're getting into here. Jack, Dave, go ahead. Summarize what's going on here in this. This is where you are also bringing up Benjamin Franklin.
Right, and just before that, you see that subparagraph 3 there. It talks about requires disclosure of a privileged or other protected matter. as I mentioned, this is just one type of privilege. Another type of protected matter is attorney-client privilege matter. And I know that that's another debate that's going on in this case, a dispute, because Blvd has requested, by virtue of subpoena, Wayfarer defendants' attorneys to produce their communications with their client, which, as they've argued, is protected by the attorney-client privilege. So that's another way, that the privilege can be invoked for purposes of this Rule 45. But sorry, going forward to the reporter's privilege. Yeah, I mean, what this does is it essentially shrouds disclosure of either confidential sources, the identity of those sources, or the information provided by those confidential sources. And there's a test that needs to be met by the party requesting disclosure, requesting to overcome that privilege. It's a heavy burden. The test is it's intense. I mean, you have to make a compelling showing, whether by the statutory privilege or the other two privileges I mentioned. One in particular, first, you have to show that it's relevant material. The second one, which is key here, is that the information is not available from other sources.
Right.
And the third one is that there's a compelling interest in requiring the disclosure.
So, and the second one is going to be a huge hurdle, because the vast majority of the information that's being requested, guys, is communications between, again, media sources and news providers and the defendants themselves. But the defendants themselves are parties to the action, and you first have to exhaust efforts to garner the information from parties before you burden people, again, who don't have a dog in that initial fight.
Right. And that's the same argument that's made later in the motion on the Rule 45, the burdensome argument.
Yep.
Rule 26 defines burdensome as any information that is duplicative, cumulative, or available from other sources. So we're sort of attacking it from multiple different angles, but all based on the same thing, that the information they're requesting is within the possession or control of the Wayfarer defendants who are parties to this action, and that it needs to be obtained from them rather than a non-party who has no dog in the fight and shouldn't be burdened with cost, expense, etc., of having to comply with a subpoena like this.
Now, look, there's a lot of great work. We're going to read this through, and I'll make sure this is accessible. You guys can look it up on, I guess, Pacer and stuff. The case number and stuff's on here. So if you're all you law nerds want to get out there and find it, you can. But I want to get to the BuzzFeed article you brought up, because that was a great pull and a perfect example of what it is. Can you explain that one for us?
Yeah, sure. It's actually relevant right now. I mean, it's a 2017 case, but this is sort of in the news again. This BuzzFeed case had to do with BuzzFeed publishing an article back in 2016 regarding the Christopher Steele dossier. Have you heard of the Steele dossier relating to President Trump? They sued BuzzFeed, the defendants, sued BuzzFeed asking for the identity of the source that provided this Steele dossier to BuzzFeed. BuzzFeed said, we're not going to produce that. It's protected by the journalist privilege. The parties litigated it, and the courts found that the information was indeed protected under the journalist privilege. Now, that all turned on the main argument made by the parties requesting disclosure, was that BuzzFeed isn't a journalist or a news organization as defined by the statute, because they don't have a printing press. They don't produce newspapers. There's no magazines on the shelves. They don't have a television or radio channel that they're, broadcasting over the public airwaves. So they're not the news. And the courts found, no, that's not the case. Even though they publish only online and through Facebook and YouTube and whatnot, that doesn't mean they're not the news. In this current culture that we live in, we're living in the internet age, news is on the internet. And a lot of people aren't looking at traditional print media anymore. In fact, we've cited in there some statistics that were quoted in surveys that show that print media consumption and television and radio, for that matter, is on a precipitous decline, whereas online media consumption, YouTube, Twitter, you name it, is just exploding.
Dave, to talk about, if you will, how that relates back to Benjamin Franklin when he was 16. Again, because there was no internet back then, but his brother was essentially similar. He wasn't a huge news source. He wasn't the New York Times, right?
Yeah, it was a small independent newspaper, exactly, the New England Courier. Small paper. His brother started it after having worked as a journalist for other papers. I think that really goes to the sort of the heart of what this privilege protects and what was the Constitution, what was the mindset of the framers of the Constitution. And that's mentioned here in the Brandsburg case, which is a Supreme Court case that says I have to find it here. It mentions that the press is not just people with massive printing presses that are sending stuff coast to coast, but it's the lonely pamphleteer. That is also part of the press. The press incorporates and encompasses everything from the guy standing on the side of the street with trifle of pamphlets, right, all the way up to the New York Times
with leaflets, and that's really important in this case, guys, because that's the whole nature of free speech. If free speech means anything, it's the opportunity for someone who doesn't have significant resources, who may not necessarily be the New York Times, or who may not necessarily be an audible voice and have multi-billions of dollars, or have a huge platform, or have made movies, or are actors or actresses. It's the individuals who may not have those same resources who are able to transmit information. They should be given a right to transmit information. We can compare our country to other countries. Take Cuba, for example. The press and the media is controlled by the government. That's the whole point of the First Amendment. It's to enable those who are not in power to be able to provide information to the masses, so the decisions that are made and the perceptions that are created are a function of the truth and not merely what the people in power want to be perceived. It's crucial.
That's right. And Andy, look at page 13 is where I go into that. This was the Brandsburg case, which was 1972 Supreme Court case. And it is basically cited by every state legislature that's adopted one of these shield laws, and other federal circuit courts and district courts that have found the privilege to apply in First Amendment cases. The Justice Byron White wrote that narrowly defining the reporter's privilege would be a questionable procedure in light of the traditional doctrine that liberty of the press is the right of the lonely pamphleteer, just as much as of the large metropolitan newspaper. He goes on to say that, broadly speaking, the press in its historic connotation comprehends every sort of publication which affords a vehicle of information and opinion. And if that doesn't apply to Popcorn Planet, then I don't know what does. Clearly, they fall within that contemplation of what the press means.
Well said. And also, you guys did this amazing homework showing that we have more subscribers than a lot of these other big press outlets that they're defining, which I'd never done that before. You guys did that.
I was impressed.
That was a really, that was like, oh, but actually, that's pretty cool. He went through and added a lot to sort of reaffirm my bio and prove again, which I gave him some insight. But yeah, it's amazing because this is a new day and age of content creators, right, Jack? We're content creators, and I love it. You're like, you're not a damn content creator. That's a kindergartner with a crayon as a content creator. It's true. We should stop using that term, and we shouldn't be letting them say it because this audience knows it too. We report news here. We do. And news is a lot of things, right? Entertainment news. Yes. There's a lot of versions of news, but people come here. Our audience will tell it to you first. They come to us before a lot of other outlets. So, Jack, how important is this case for the rights of all journalists, press, media who is doing this job, that celebrities and their endless husbands' bank accounts can just go out and intimidate and try to shut down or get whatever they want from the creators that are speaking a little bit not to their liking?
Firstly, thank you for quoting me. You're right. And that's exactly what I told you. Stop using the term content creator. Content creators are kindergarten students who color with crayons. You are a journalist. And again, when Professor Dave talks about the pamphleteer, you're more than merely a pamphleteer. I mean, you have a significant following and you can make a significant impact. But in terms of defining or qualifying the importance of these particular issues, I have no other word other than fundamental. This is absolutely crucial. A stand has to be taken because the First Amendment can be eroded. Again, we talked a little bit about it yesterday. It doesn't happen abruptly. It doesn't happen by catastrophic means or revolution. It happens slowly. In much the same way that water is a powerful source, you continue to drip that on rock, right? Over the course of millions of years, it erodes the rock. And someone has to take a stand. So this particular issue, while some may otherwise scoff or otherwise discount the import, given the nature of the subject matter, because we're talking about, at the end of the day, about a Me Too sexual harassment, claim by a female actress against a studio. We may scoff at what the substantive matters is, or substantive matters are, but the nature of the fight, the nature of the conflict, the nature of what is at stake is absolutely fundamentally important. It's crucial. It cannot be sufficiently, or it can't be overemphasized. It is absolutely fundamentally necessary to take this stand, or else we see the crumble of the freedoms and rights to which are not given to us by statesmen or politicians. It's given by the hand of God. I mean, our founding fathers understood those notions, and they codified that in the United States Constitution. And for more than 200 years, we have proven globally, worldwide, that it's the best, the finest, the most fundamentally sound way of protecting human rights than any other system in the world. And we have an obligation, both ethical, both legal, both spiritual, to properly fight for that. Again, I can't stress enough. You asked me to qualify how important it is. It's fundamentally important, Andy. That's how important it is.
Yeah,
do you think,
I mean, pragmatically, you look at it from a perspective of, like Jack said, there's lots of different types of news, and is this considered, the news, entertainment news, if you will, of the most importance? It doesn't matter. That isn't the question.
Right.
News is simply defined as anything that is of public concern or public interest. The fact that we got people here, 1 million subscribers, 360 million total views, I would say that qualifies as public interest.
Well, I would even argue as well, I'd actually like to hear your input on this. One of the things that has shocked me the most about this whole controversy, this whole drama, is that there are so many content creators who will go on Pacer. They have gone through the process to be able to go on Pacer as, not a lawyer, but as just an American citizen, or I personally have a Pacer login as well. I am not an American citizen. But we go in, we get those legal documents because they're public. They're public
That's right.
information. And then you read them, and people who have literally only done that have been hit by these subpoenas.
Right.
Kim,
It's absolutely ridiculous that how is it that this is even allowed, in the sense that you have these creators that really, they're not that large. They're reading these documents. They're giving their opinion on a public case. And yet apparently in the United States now, that's not allowed. I have a lot of questions about that as someone who is not an American, because my understanding has always been that you guys have the right to do that, but that apparently is under fire. So I'd love to hear your thoughts on that.
That's only true, though, if these rights aren't defended. And that's what we're trying to do here. I mean, that's the point. It is, if you cede to that type of pressure, and that type of bullying, if you will, then yeah, it's going to be, it's going to harm the flow of information. It's going to restrict the information that the public has access to. But if we fight for those rights, if we stand here and we make a stand, and everybody who has an interest in that participates, then those rights will be protected. We have to jealously guard those rights. Otherwise, they will go away. And that's why we're doing this. That's what
you bring up actually some excellent and very sophisticated points, Kim. Number one, Pacer. Pacer is the computer system, or the case management program, if you will, for the entire federal system. And the whole nature of the United States is based upon transparency and freedoms. So that anyone, you don't have to be a citizen, you don't have to be a lawyer, you have public access to the court systems and to documents that are filed. In every case that I try, we were supposed to try one yesterday, we wound up getting continued. Anybody off the streets can walk into the courtroom and watch the proceedings. And that's the importance. That's the freedom of making sure that people can be witness to prevent abuses from otherwise occurring. The second thing is, again, as Dave indicated very, very astutely, it doesn't matter what the subject matter is. Again, people can discount the import of this particular case because, oh, come on, Jack, this isn't a matter of national security, man. Why is your office getting involved? It's not a function of what the underlying subject matter is. It's a function, and the import is being able to disseminate information about whatever the subject matter is, be it a Hollywood scandal or be it a matter of national security. That's what ultimately garners and it wins our protections, and it maintains and preserves our freedoms and protections. That's why this is a fundamentally crucial case, guys.
Well said. Look, there's more we're going to go through. We're going to read you the whole document. If you guys missed the full live show, we were here with them for a lot more, and we read a lot of it. You guys can head over to our website, PopcornedPlanet.com. Head on over to the news tab. You'll go over to the exclusive content section. If you're a member, you can get all the replays along with our documentaries, so much more. Plus, check out our merch store. All of this will help support not only our attorney's fees, but the documentary and everything we're doing. You guys helped us to be able to find these fantastic trial attorneys. So grateful to you both. Thank you so much for being here, for helping us go through this. We got a lot more show, guys. Don't go anywhere, but just wrapping this up for the replay. So click it out on PopcornedPlanet.com if you're watching it late. Well, there you go. That was an amazing show. If you want to watch the full replay where we go through the whole motion to quash, you can become a member on our website. Go to PopcornedPlanet.com. Sign up. We made it as obvious as possible. Pick your tier. This is our new Patreon thing. You can go from Patreon, join us here, become a member. We're going to start making this a clearer, funner place to be. Sign up, and then you can also access the documentary stuff, as well as the merch store, news updates, exclusive member updates, and other news things. That's the destination to go to. So you can also support our amazing lawyers. If you liked them, drop a couple bucks in the legal fund / documentary fund. We could still use your assistance because we don't know how long it's going to take. While everyone else is getting their subpoenas thrown away, we're just getting started. This is war. We're getting into it, and we are not going to back down. And we can do this thanks to all of you. So thank you. And thank you, the amazing It's Kim. Go support her over on YouTube at It's Kim. Give her a follow. She'll be live now more often, I hope. And after a break, please schedule a break at some point, Kim, too. You've deserved one for a longest of times.
We're going to talk later.
Love it. And all of you, I hope you have an amazing day. Sorry I've been a little sick during the stream, but we will carry on. And we got a lot more coming your way. So stay tuned here on Popcorn Planet. Nerd Report is next. Head on over there live if you're watching. If you're not watching live, click on these videos if they popped up. Thanks, everybody.